So let's take a hypothetical trademark here. We have a non-stick electric grill. We want to create a brand for it. Well, what if we name it Grill? Is that going to be a good trademark for it? Well, the answer is no, it's not, because it is a grill. So the U.S. Patent and Trademark Examining Attorney is not going to allow you to remove grill from the public domain. It would give you an unfair advantage over your competition, which needs that term to describe generically their competitive product. So sometimes clients might want to say, well, let's just name it The Grill and add the definite article to it. Is that going to carry the day? No, it's not. It is still going to be deemed a generic trademark. What if we look at the grill and we come up with another trademark? Why don't we call it Parrilla? Parrilla in the English language doesn't exist, so could it be a good brand identifier? No, again, it is a translation of grill into Spanish. So under the transliteration rule, the U.S. Patent and Trademark Office is not going to grant that trademark. In fact, they will deem it generic, even though it is in a different language. Well, what if we take this grill and we call it Gas Grill? Can we get that? It's not a gas grill, so it's got to be pretty unique. Well, the problem is it's misdescriptive. So the U.S. Patent and Trademark Office will probably not grant that because it's an electric grill and it's absolutely misdescriptive and deceptive as to what the actual product is. What if we call it the Super Grill? Well, probably not. The U.S. Patent and Trademark Office is going to look at the word super and they're going to say it's merely laudatory. We can't call it the best grill, the top grill, the #1 grill. That's all just commercial advertising and puffing, and it does not serve as a brand identifier. What if we call it the Foreman Grill? The Foreman Grill sells really well. Why don't we call ours the Foreman Grill and be able to use that trademark? Well, you can't, because there would be a likelihood of confusion and you have an existing federally registered trademark. Not only would you almost certainly be denied registration of the Foreman Grill, you might also subject yourself to some liability for the owners of that brand. Well, here's another variation. We don't spell it Foreman Grill, we spell it 4, numeral 4, M-A-N Grill. So therefore we have a distinction. Will that carry the day? Again, no. You're sensing a pattern here. Four-man grill and Foreman Grill, those two presentations, whether one is a numeric character and the other one is F-O-R-E-M-A-N, they're phonetically identical. So the U.S. Patent and Trademark Office examining attorney is going to say there is a likelihood of confusion between these two brands, even though the alphanumeric characters are substantially different. They're phonetically similar or identical. There's a separate category of trademarks that are entitled to even broader protection than we normally see. These are called famous trademarks. Some of them might be Apple, Ford, Coca-Cola, Kodak. Normally, you can have a identical trademark to one that already exists, provided your products are not overlapping. You may also have identical trademarks for the identical product as long as they do not travel in the same channel of commerce. For example, one is in the retail environment and the other is in the wholesale environment. But when we get to famous trademarks, these are entitled to protections against tarnishment and dilution. Their ownership interest is actually enhanced. So even though Coca-Cola, to my personal anecdotal knowledge, does not sell glue, we cannot brand Coca-Cola glue and sell it and be free of any liability. Coca-Cola owns enhanced rights to that, and by selling glue, even if it is the best glue in the world, would be diluting their right to be able to use that trademark and that brand as they see fit. Even worse is if we sell glue that's really, really bad and perhaps causes injury, then there's an additional claim to tarnishment that not only are we diluting their interest, but we're actually hurting the quality of their brand.